Hi, this is John Strohmeyer with Strohmeyer Law. Today we're going to be talking about estate administrations, and specifically the second question we ask whenever we're dealing with an estate administration. How much administration will we need for this estate? The important thing to think about with this is we have a range of options when administering any estate, and we want to make sure that we get the right amount up front of power for whoever our family members are going to be, because we want to make sure that we don't have to go back and ask the courts for more power later on. So if we think about it as a continuum from no administration all the way up to a full estate administration, we've got a few options in between where we can think about this. On the low end of no administration, we have some options such as an order of no administration, where we're asking the court to just not even administer the estate. We may do something simple like just send the last will to the courts and say, here it is. We know that we're required to file the last will with the county clerk under Texas law, but we're not going to do anything else. On the other end of the spectrum, we have full administration. Now, there are a few varieties of administration. There's the traditional Texas independent administration, where an executor or an administrator of the estate is appointed. They then have the power to operate to clean up and tie up loose ends for the decedent's estate, and they're going to operate largely without the control or oversight of the court. This is a feature of Texas probate administration where courts are only involved when necessary. Another version would be the dependent administration. Dependent administration is going to require that the executor or the administrator get approval from the court for every action they take. Do they take money out of the estate? You better get a court order approving it. Did you receive an asset? You better tell the court about it. Do you want to make a distribution to one of the beneficiaries and close the estate? Go talk to the court before you do it. Then we have a number of options after our full administration and no administration options that are somewhere in the middle. One of them that confuses practitioners and people alike outside of Texas is known as the Muniment of Title. This is a unique Texas administration option where the only thing we really care about is taking title to assets that are identified in the last will. What we're hoping is that the last will is clear enough that we don't need to administer the estate. We just need to transfer title to certain assets. So if we have a piece of real property or a bank account or a brokerage account, if we go with the Muniment of Title, what we're asking the court to do is say, hey, we don't really need the full administration. We don't have any debts to clean up. We don't have any creditors that we need to deal with. There aren't any final issues that we need to deal with. We just need to take title to these assets, and the beneficiaries can sort out among themselves who is entitled to what. When we have this Muniment of Title, what we're not going to have is an administrator or an executor of the estate appointed. We'll still go to court once to have the will admitted, but it's only going to be for the limited purpose of this Muniment of Title, which will operate to transfer title. So you can take the order admitting the will and take it to the bank or file it in the property records as a way of showing how the asset got from the decedent to the next in line. Another option, if you don't have a last will, would be the small estate affidavit. Texas has a fairly broad small estate affidavit program, though it does require that you die without a last will. What happens is if you have certain limited assets and you fit within the confines of those requirements. So real property is not going to anybody other than a surviving spouse or minor children, and you don't have any real property other than your homestead, and certain assets are valued at less than $75,000. The family plus two disinterested witnesses can sign the form and get it filed with the probate court. The probate court will review everything and then sign off on it. That order then is also sufficient legal authority to go to the banks and other custodians of the decedent's assets and use it to transfer title. So we talked about our second question today. How much administration do we need? There are a few options here in Texas, and it depends on what the family is looking for and what those specific assets are going to be. On the low end, we might be looking at no administration, where we just send the last will to the county clerk and say, thanks very much. We want to make sure that you have the original last will in accordance with Texas law. On the other end, we may need a full administration because we have creditors to deal with. So this would be either a dependent administration or an independent administration. In both cases, we'd have an executor appointed. Then there are going to be a number of options somewhere in the middle. So we might be looking at either a muniment of title or a small estate affidavit. So these are going to be situations where we don't have an executor or an administrator appointed, but we do have a way to transfer title to assets. Thanks for watching. Remember that nothing in this video was specific legal advice for you. If you have a question and you need something tailored to you, you're going to need to talk to your own attorney and not trust some talking head on YouTube. Liking, commenting, or subscribing to this video will not create a legal relationship with me or with any other attorney. Thanks and have a great day.